Alexis, I've been a lawyer for over 40 years, and I will occasionally get an email or a text, and it goes something like this: Tom, my mom has passed away. She had money in the bank. I'm trying to get access to it, and it was in her name only, and the bank says I need a letter. And as soon as I hear a letter, I know what they're talking about.
Me too.
What are they talking about?
They are talking about a document called the Letters of Administration, or also known as Letters Testamentary. And basically what that does is it appoints someone to conduct business on behalf of the estate, and it gives that person the ability to access that bank account.
So again, people, they call and say, "Oh yeah, Tom, all I need is a letter from the probate court." They think it's like literally a letter, but it's
like
not.
They think we write the letter.
Exactly. It is. What they're really referring to, and they just don't know it yet, is they're referring to letters of administration. It is signed by the judge. It appoints an executor, also known as a personal representative of the estate, and it gives that executor the legal authority to go out and transact business on behalf of the estate.
Absolutely.
So when I tell people that mom has passed away, and they'll say, well, just go down to the bank and show them mom's will and mom's death certificate, and they'll turn the money over to them. Well, we know that that's not true.
That is not true, and the bank will not do that for you.
So that bank account's going to be locked up until the court appoints an executor, also known as a personal representative, and issues letters of administration. And I tell that client, look, when you go down to the bank with your letters of administration, the bank will do whatever you ask them to do.
Absolutely, because they see that person is the one that's supposed to be there talking to them.
So, folks, if you got a question about probate or any other area of the law, we're standing by to talk to you right now. We would love to get your legal question. 407-916-5400. Text us 23680. Alexis, since you're doing probate now, I'm going to tell you about a case that I heard of, and this probably goes back 10 years ago. But it was a man who worked in a probate. He was a probate clerk at the courthouse. He worked for the probate department, and he had the bright idea of getting a fake certified copy seal. And so he worked for the probate court. He was a clerk, but he would make fake letters of administration, now put that fake seal on it, and go to the bank and get access to people's money that way.
Oh my gosh.
Of course he got caught.
Yeah.
And, got put in jail for it. But, when we talk about letters of administration, they got to be signed by the judge. They got to be, you got to get certified copies from the court clerk. But at the end of the day, it is a piece of paper.
It is a piece of paper.
And if somebody wanted to, fake one, and by the way, when we get certified copies, as you know, we pay the clerk for certified copies, and they put a certified copy stamp on it, which is in red ink typically.
Yep.
And the court clerk is personally signing every one of them. So if we say we want 5 certified copies of a letters of administration, they got to print it 5 times. They got to stamp it 5 times. They got to sign it 5 times.
Exactly. Each individual copy must be stamped, dated, and signed.
Exactly. So, and if you go to the bank to do business with it, they're not going to take an ordinary copy. They want a certified copy.
They do.
And so that's part of what we do, is to order people certified copies. But you can see how that, a smart clerk can say, hey, all I got to do is buy a fake red stamp, prepare some fake letters and sign it and stamp it, and I can go get access to people's money. And sure enough, he was.
Oh my gosh, that's horrible.